Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host. Hello, lovely people. Another Saturday is with us here, and we're looking at another opportunity to discuss some of the things when it comes to the law. And we're doing that courtesy of BWF Solicitors, our trusted partners when it comes to the law. This afternoon, there is a very interesting discussion we're going to have, and we're looking at visa cancellations and all the other bits. What is the law saying? How can we circumvent all those situations and get around it to make sure we are doing the right things here in the UK? Once again, my name is Oreku Frimpon, and I welcome you once again to The Community and the Law, live on BWTV. We're streaming live on Facebook and YouTube at BWF Solicitors and at BWTV UK. Let's get into it together.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Once again, I warmly welcome you to another edition of the community and the Lord. Today, the first Saturday of the new month of May 2026. Yesterday, the 1st of May, was World International Workers' Day or Labor Day, so to speak. And on this occasion, on behalf of BWF Solicitors, on behalf of BWTV, we want to congratulate every worker the world round. What we are saying to you is that you make this particular world go round, and what we eat, what we wear, what we put on the table, everywhere is through your sweat and toil. So, on this auspicious occasion, on behalf of BWF Solicitors, we want to say, are you cool? Or well done to all of you. My name is Oriku Frimpon, and I have the singular honor of hosting this event. We're talking about the community and the law, and for the next 2 hours, we're going to look at a very interesting topic: judicial review application against UK visa refusal or cancellation. So we're looking at what the law says, what the processes are, and what evidence it is that we need to put up so we can do it right. Now, we will be unpicking that so very well. Judicial review application, what is that? And when we go on judicial review and put in that application, we're putting it against what? This time we're looking at putting that application in against visa refusal or cancellation. So that tells you probably we'll be looking at the skilled worker route and all the other bits around it. So we will be picking some evidences. We'll be looking at the processes, and we'll be looking at what the law itself says. So gather yourself around. Let people know that we're live on Facebook and YouTube at BWF Solicitors and at BWTV UK. A resource person, as you would have seen on poster, would be lawyer Charles Asma from the stables of BWF Solicitors. So lawyer Asma will be on and will be giving us that. But before then, let me tell you about some of the experiences that people have been having with BWF solicitors. Kia Sante comes in and says, if anyone is facing legal challenges, he strongly encourages you to run to BWF solicitors. You'll be safe and you will be in capable hands. That's one from K. Asante. Asante is very satisfied. He found his way to BWF solicitors, and his case was professionally and properly handled, and he had some success out of that. BWF solicitors, let me tell you, they are on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. The postcode is N15 4NP. You can visit them Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And you can call them 0208 493 7340. I say the number again: 0208 493 7340. Or in emergency situations, you can contact them. You can send a WhatsApp message, you can do a voice note, you can send a text message, or even call the number 077 127 61884. 077 127 61884. BWF solicitors are trusted partners when it comes to the law. Now, people are experiencing a lot of positive things with BWF solicitors, and I want to invite you to also go ahead and experience that wonderful service by visiting them. I've told you where they are. Fourth floor of the Anna House. Now, if you're going by public transport, you can get on the Victoria line and get off at Seven Sisters. Now, when you get off the train, use exit number 2. Exit number 2 takes you to the frontage of the Anna House, and you climb up to the fourth floor. That's where you meet BWF solicitors. The family, the workers there, and everybody is so welcoming. And I believe that you would have a good experience and give us some feedback as K. Asante is giving. Now, if you want to express your satisfaction and also give some feedback, you can do that on Google and give us a review, or visit the various social media platforms of BWF Solicitors: Facebook, YouTube, LinkedIn. There is a TikTok channel and on WhatsApp as well. So don't forget that when something hits you so positively, you have to share it with other people. Like here, Asante is saying and asking that, are you facing any legal challenge? The encouragement is that run to BWF Solicitors, you'll be in safe and capable hands. Thank you very much, Asante. BWF Solicitors. Now, let's go over again to the message and then look at what the advert is saying, and we'll give you the location on all the other things again. And when we come back, I will be looking at some of the things that BWF Solicitors does for us, a nugget they give us every day, the test of our knowledge, and all the other things. And there's staff motivation that we will be looking at as well. This is the community, and the law will be right back.
From London to Ghana, yeah. BWF in the house, let's go. Integrity, excellence. We rise together. We stand with you. We stand with you. BWF. When the path is tough, we'll pull you through. From Seven Sisters to Accra too. We stand with you. We stand with you. On the high road in London town. 2028 on a house we're found. And Christine the sound. Family, immigration, wills and probate, we're around. 30 years strong in the game. We got a law in our name. When life gets heavy, we lift the weight. Together we claim the fame. Oh, you want a dream? You need a team. BBUF by your side, shine like the stream. From a class golden.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
So yes, share the experience you have and also come join us. This is the community and the law is brought to you by BWF Solicitors. I mentioned earlier on and before the break, you saw some clients also expressing their appreciation and the satisfaction they get when they deal with BWF Solicitors. Now, let's get into some inside business. BWF Solicitors, at the end of every in fact, at the start of every week, so to speak, they give us something to chew on. something that would help us understand what the laws are saying. And this time around, they say there's great news because the Home Office has made it possible, to access public funds even if you are on the 5-year route. Applicants on the 5-year family or private life route can now be granted leave with access to public funds. And what are some of the key points we're looking at here? It applies where there is destitution or risk of destitution. It applies where strong child welfare or exceptional circumstances exist. And also, it applies where no automatic switch is to the 10-year route. And what does this mean? Applicants can stay on the 5-year path to settlement. No recourse to public fund is now flexible, not absolute. So there's a tip here they are giving us. BWF solicitors is saying that this is a crucial opening to protect vulnerable clients without delaying indefinite leave to remain, permitting access to public funds. 11th February 2026 is where we picked up this one from, and I will be taking you through that. So you would realize, as Lawyer Asma will explain, if you have no recourse to public funds on your visa or your status here in the UK, you can't access benefits here and there. There are certain things that you cannot apply to, and you would have to cater for everything. But what they are saying that where there's destitution, Asma, I will ask you to explain the destitution or risk of destitution. You could put in an application and see if you can access public funds. Child welfare situation is here being mentioned, and if there is any exceptional circumstance around you, you could make an application and access public funds. And then there's no automatic switch to the 10-year route. So well, those details I'll leave for the lawyers to really look at for us. So look at this critically, and when we have had the explanation, I will test your knowledge on this one to see if you would be able to give me an answer. And being so good, let me ask that question. Now, consider this scenario. Julie Walker was granted 5 years leave to remain in the UK as a parent of a British child last month. Julie was made redundant and has since exhausted her savings. She's now struggling to pay rent, buy food for herself and her son, and under her existing visa condition, she cannot claim universal credit or housing benefit to prevent homelessness. Julie is worried that accessing public funds would affect her indefinite leave to remain application when she's due, because on her visa status, she cannot access public funds. So let's speak to the situation Julie is in now. So let's advise her. And I've got two options for you. So it's either A or B. So think about it carefully, looking at the nugget and the scenario I've just given you. Accessing public funds would affect her indefinite. Or you could also say, now, accessing public funds will not affect her indefinite, so she should go ahead and put in the application for public funds, whether universal credit or housing benefit or any other benefit that she may fall into. But let me go back to the nugget. Even though the lawyer has not explained, let me go back to it and look at what is changing. And we deem that to be great news. And we're saying that the Home Office has made it possible to access public funds, even if you are on the 5-year route. When we say 5-year route, who is on there? Who qualifies to be on there? There's also the 10-year route we always talk about. Who is put on the 10-year route? Now let's continue. Those who apply and are put on the 5-year family or private life route can now be granted leave with access to public funds. That tells me, or that pretty much tells me, that people on the 5-year private life or family route are not given access or permission to access public funds. But they are saying that the Home Office now can grant leave with access to public funds. Now, what the key points, as I mentioned earlier on, we're looking at three key points. The situation applies where there is destitution or there is a risk of destitution. The situation applies where there's a strong child welfare case or exceptional circumstance in the life of the child. And the situation says that there's no automatic switch to the 10-year route. So what this means is that applicants can stay on their 5-year path to settlement. No recourse to public funds is now flexible, not absolute. It is crucial opening for us as we try to protect vulnerable clients without delaying their indefinite leave to remain. This one was quoted from the statement permitting access to public funds dated the 11th of February 2026. So I come back to the scenario, the question I gave you about Julie Walker, who was granted 5-year leave to remain in the UK as a private of a British household, family life and private life application. Last month, she was made redundant and has since exhausted her savings. She's now struggling to pay rent and buy food for herself and the son. Under her existing visa condition, she cannot claim universal credit or housing benefit to prevent homelessness. So she's worried that if she puts in an application to access public funds, it would affect her indefinite leave to remain application when she is due. So I'm asking, is that true? Is that correct? Is it true that accessing public funds will affect her indefinite, or is it that it will not, accessing public funds, will not affect her indefinite? Think through it and then give me an answer. Not now. You can put that in the comment section. Anyway, at BWF Solicitors, both Facebook and YouTube, and at BWTV, both Facebook and YouTube. And those of you who have joined us that you have not identified yourself, I want to go back to the housekeeping and ask you to give me some comments. Let me see if you are here before I go into the main discussion. Tilly Duma comes up where please kindly share, comment, and like. Thank you. We'll give you thumbs up as well, Tilly. Thank you very much. God bless. Marigina Freeman. Hello, everyone. You're all welcome. Yes. Thank you very much. We'll give you a wave and a smiley as well. Thank you very much. Adesafu, please share when you join. We pray thee. Ade, thank you very much. God bless you. We go on to Sandra Fraser comes up with the contact details where you can reach out to specialist immigration solicitors if you have any comment, any concern, any issue you want them to help you address. Lawyer Eunice, Lawyer Charles, you have their numbers on there, 075-3581-3910. Uncle Charles, 079-4763-6037. And the main office number is 0208-493-7340. And in all emergency situations that I keep mentioning, 077-127-61884. BWF Solicitors on the 4th floor of the other house, 214-218 Tottenham High Road, Seven Sisters in North London. 0208-493-7340 is the telephone number. Citizen Kojo, good evening, everyone, to you as well. Good evening. Thanks for joining us, Citizen. If you have a question, if you have any concern, and if you would want to contribute to the discussion that we're going to have, you can put that in the comment section down below at Facebook, at BWF Solicitors, Facebook and YouTube. Tilly, hello, lovely family. Once again, thank you very much. This afternoon, remember, we're going to look at judicial review application against UK visa refusal or cancellation. What does the law say? What are the processes? And what evidences do we have to put together so we can successfully make that judicial review application against UK visa refusal and cancellation. Well, I will invite you to join us to say thank you to BWF Solicitors once again. And when we come back, we go straight into the discussion.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
You in a video no you can about customary marriage, a friend of proxy marriage, although say and proxy marriage. Into UK, send your name no worry what Ghana na wudi hokra or the paha ubiti media application. Bimu se wunti me but ubiti media. So worry what Ghana if you are worry a friend of customary marriage, bimu friend of proxy marriage. What about UK? Ubiti me use to your application. Into the may mouse and a home office immigration for a refusal application. 2% of your application are successful. Now home office for approval application till you make it. First of all, so I want a customary marriage. Your case be a friend of Kuju, UK case 2016. I said Mrana, Krona or Warren one, Mrana one will see the Ghana Mras. Ghana Mrana say, Ghana Mrana say, so we a customary marriage. I will say we you be Gina Hua or by yes I don't know. It's usually alongside mommy and our papa or Busian 4 and now I will near Busian 4 or now for 4. I was so mal to me. Into obey yes, Anna, my advice is obey a statutory declaration every UK and our power of attorney. And now even a simple consent letter with no ID, our dear account say 1 hour to me, so Munjina on Yawa. So we obey Beman and so Massa, a Senabaya in Kunia, Yena, and Ma sa to me. Omujina or Nabusian for no best swear statutory declaration. Now, what they call KMA, AMA, Metropolitan Assembly, District Assembly, baby, registry, marriage registry will be a qua registrar and more certificate be a friend of shadow 1. Year, once on the statutory declaration account. My registry and some letter and count. Letter na the Abaya and say, Adia or my Jenny, and our red and so much Ghana. If you want, Ebeko Foreign Affairs on the bullet charges, Ebeko Court on the bullet charges. Why you win in a year bar and yet shed Safako Ghana High Commission? But we bet me a Fako on almost some bullet charges. Name bomb. Why you win in a year no so I was all the man Ghana name and our lawyer to Ghana Mranas. Or one in dear for Ghana or real. Or said the lawyers no, Pinomunina no more to Ghana Mrasia, who win in dear for Ghana our real. Or your warrior no pay strong. ɛnyɛ wiase nyinaa na ɛwɔ saa awadeɛ yi nti wɔ sɛ yɛ Ghana ni a wɔte ase lawyer deɛ ɔbɛyɛ ni first of all ɔgye wano asɛm yi a ɔno bɛtwerɛ letter long letter ɛde aka ho akyerɛkyerɛ Ghana mmara no ani so ɛde Ghana law nankasa aka ho home office sometimes ɔmo yɛ mistake quote law bi ɔmo sɛ yɛ Ghana law sɛ na nyɛ Ghana law nti lawyer no de law no bɛka application no ho ɛne ne letter tenten a wakyerɛw na ɔde kɔ a na wahwɛ ahyia mu sɛ ɛbɛdi mu nti dɛn na ɛwɔ sɛ woyɛ fa Ghana ni lawyer ɔte Ghana awareɛ ase 2 ansa na abusuafoɔ bɛgyina hɔ ayɛ awareɛ ma ɔmo tumi by power of attorney statutory declaration anaa letter a wɔde wɔ ade aka 3 abusuafoɔ no bɛsɔɛ statutory declaration na ɔmo de akɔ registry ma marriage certificate no bia ɔmo ma ɔ letter de aka wowie a akɔ foreign affairs fi foreign affairs a akɔ judicial service if judicial service na ɛba UK a na ebiom wɔde akɔ Ghana High Commission ɛnyɛ ɛhyɛ ba wɔde kɔ a ɛboa wayɛ wei nyinaa akyi no obi a awareɛ no som bɔɔma no otwa awareɛ no ho mfo nti awareɛ no ho mfo ni wɔ yes nokorɛ sɛ baa ne bɛrima no ni abusuafoɔ no wɔ nti ma abusuafoɔ no ntwa engagement photo wɔfrɛ no engagement ɛnyɛ engagement ɛyɛ awareɛ wɔn twa ho mfoni no wie a na wɔyɛ wɔ application a wɔde mfoni nso aka ho ɛwɔ awarehyɛ mu sɛ wodi wei nyinaa nso a ɛbɛdi mu ama sɛ wopɛ advice bi a wobɛtumi afollow BWF solicitors na wafrɛ ne aboa.
Well, thank you very much for sticking around. These messages are prime. If you want further resources, you can visit the website of BWF Solicitors at www.bwfsolicitors.com www.bwfsolicitors.com. Yes, we will continue to bring you some detail before we start the discussion. Judicial review application against UK visa refusal or cancellation is what we're going to consider this afternoon. We're looking at the law, the process, and the evidence. So get yourself ready. If you have a notepad, you can pick up that and draw some notes. Now, in-house, we have every month the person that we consider to be the employee of the month, and we have our very own Miss Asma, as the employee of the month of April 2026. Congratulations to you. She just joined the organization a few months back, and she's putting all the efforts. She's been working so very hard, and members of staff have voted Mrs. Asma as the employee of the month. Congratulations, we doff our hat to you. It's just the beginning, and I believe that more great things will happen when it is that we have you around for a longer time than before. So on behalf of the members of staff, on behalf of clients, on behalf of the BWF Solicitor family, and on behalf of BWTV, we salute you and congratulate you for being the employee of the month of April 2026. Well, when we get to the end of May, obviously, maybe you want to defend your title, as it were. So yeah, ma'am, congratulations. Thank you very much, and enjoy the stay. The Home Office has made it possible to access public funds, even if you are on the 5-year route. Applicants on the 5-year family or private life route can now be granted leave with access to public funds. And the key points we can take away from this one is that it applies where there is destitution or the risk of destitution. We also look at a situation where there's something exceptional in the life of the child, strong child welfare situation, section 55 of the law. And of course, if there is no automatic switch to the 10-year route, we could be looking at the new directive given by the Home Office. It means that applicants can stay on the 5-year path to settlement. No recourse to public funds is now flexible, not absolute. It is a crucial opening to protect vulnerable clients without delaying their indefinite leave to remain. I asked you the question, I asked you to help me find an answer for our friend who is facing a dilemma. Julie Walker is the person I'm talking about. She was granted 5-year leave to remain in the UK as a parent of a British child. Last month, she was made redundant and has since exhausted her savings. She's now struggling to pay rent and buy food for herself and her son. Under her existing visa conditions, she cannot claim universal credit or housing benefit to prevent homelessness. She's worried that accessing public funds would affect her indefinite leave to remain application when she is due. So I'm asking that we advise. Can we say to her that accessing public funds will affect her indefinite, so she doesn't have to put in the application? Are we saying that accessing public funds will not affect her indefinite, so she can put in the application and see if she can get some universal credit or housing benefit to help herself and the British child that she is a parent to? Think about that. Have you got an answer? I don't think so. If you have any answer, you can put that in the comment. Sorry, I'm just looking for my pen. If you have any answer, you can put them in the comment section below. So we will be coming back to that. So at this moment, let me bring on lawyer Charles Asma, who is a resource person and guest from BWF Solicitors. Uncle Charles, good afternoon. I think your mic is off. I can't hear you. Well, as Uncle Charles is fixing the microphone, let me once again remind you that you can send in a text to 0739920848, or it could be a WhatsApp message or a voice note, 0739920848. And also, you can call in when the lines are active, 0208-493-7345. Uncle Charles, yes.
Yeah, Ragoku.
Yes, I can hear you now.
Yes.
Fantastic.
Good afternoon.
Thank you very
Good
much
afternoon.
for making time to join us. We're so grateful. I'll start off with the good news. No recourse to public funds has been kind of amended. The situation is a bit different. Am I saying the right things? Hello?
Yes, so we know that there has been flexibility to accessing public fund if you're on the 5-year route without affecting your indefinite leave to remain timing or how long it will take you to get to indefinite leave to remain. The whole thing is this. Before, most people will apply for a visa, and if they don't meet the requirement under 5-year route, they will be put on the 10-year route.
Right.
One of the requirements is that you should be able to maintain yourself enough or adequate income or enough financial level to be able to look after yourself without access to public fund.
Yeah.
So if somebody was on the 5-year route and later they went to get or they went to have access to the public fund, they will be converted from 5-year short route to 10-year long route just because they have put their hand into the pot, the forbidden pot. And because of that, a lot of people were not able to access public fund, even though they were in destitute situation or children involved are handicapped in terms of essential living needs. And this rule came on the back of that, so that those who are on the 5-year route can access public fund without affecting their time to indefinite leave to remain. So simply, if you are a parent, not spouse, if you are a parent, most of the time, if you are a parent and you have to access public fund and you are not sure whether you'll be migrated from 5-year route to 10-year route, the good news is that you can access public fund without fearing that you will be converted to the long route 10 years.
Well, Patrick has put in a comment like that. He says, I like that, the forbidden pot. When you mention forbidden pot, he says, I like that, the forbidden pot. Well, obviously, that is the welfare situation, the welfare system where people can apply for support for their situation. So, Uncle Charles, so if somebody is close to destitution, somebody has exceptional circumstances with their children, can they say that even though they have the no recourse to public fund on their visa situation, they can apply for that when they can give evidence of those two situations?
If you can come again, please, on that.
Yeah, what I mean is, now the change is that people can apply for the no recourse to public funds to be taken, or they can put their hands in the forbidden pot, as you put it. I have some circumstance in the life of my child. I am in a situation where potentially I could be made destitute, where I wouldn't have a roof over my head. I may not be able to buy food for myself and the children. Can I use that evidentially to say that they should give me some support from the public fund?
Ideally, yes. If you can prove that without access to the public fund, your children especially will not be able to meet essential living needs. And therefore, it's important that you are allowed access to the public fund. You still have to show, because to have your no recourse to public fund removed so that you can access public fund, you have to show that you don't have enough and you need help.
What kind of evidence would I have to give?
It's just like applying for a fee waiver. You have to prove that the money you receive is not enough to cover your rent and food. So if you pay your rent, you pay council tax, clothing, you may not be able to fend for yourself in terms of food. And not just yourself, especially the children involved. And the focus more on the children.
Okay. All right. So,
bank statements evidence, pay slips evidence, bills you pay will support your claim.
well, I have gone on and on about that, so I wouldn't touch on the quiz again, but I'll bring it later on and see if people have properly listened to you or have even followed the discussion. If you know your answer now, you can send that into the comment section. Either as one or two, or you can give some explanation, and we will come to that. Last one. Today, you want us to look at some technical aspects. We're talking about judicial review, and we're making an application against visa refusal or cancellation, and we want to do a judicial review. We want to go to the judges and say, these are things that they have done against me and all that. So you're talking about what the law says, you're talking about the processes, you're talking about the evidence. Let's look at why we would make a judicial review application. Why do we have to do that? Why don't we just have a right of appeal just for that?
Thank you very much. So judicial review simply means that you want the court to review a decision by a government or a representative of the government. For immigration purposes, the representative of the government will be the Home Office and all the workers at the Home Office, including case workers, immigration officers, Now, for visa purposes, you're only looking at caseworkers.
Okay.
The caseworker is supposed to look at your visa application and make a decision, and the decision should be in line with the rules. Sometimes they will give you right to appeal. Sometimes they will give you no right of appeal and ask you to seek administrative review. Administrative review is where you go to the same person who made the mistake to say that, can you look at it again? We call it remarking. If it were in academic discussion, remarking. So you've been failed and you are not really agreeing with the fact that you couldn't get the grade you want. Oh, this one, I want remarking. That is a review. So you mean in visa immigration purposes, we call it administrative review of the refusal decision, knowing that something has gone wrong. And it's usually within the rules, that the rules were not followed properly. And that is why you've been refused. Now, there are instances where you will not be given right of appeal, especially visitors visa applications or cancellation of your visa or curtailment of your visa. When that happens and there's no right of appeal or there's no right of administrative review, your only remedy is judicial review. Somebody will ask, why is it that you've been told no right of appeal, you've been given no right to administrative review, but you can go for judicial review? Judicial review is an automatic remedy set out within the rules under Section 6 of the Human Rights Act 1998, for example. It says that any decision of the government that is inconsistent with human rights will be a breach. And so even if it's a human right matter and you don't have right of appeal, you still have right in law for the decision to be reviewed under judicial review. And judicial review cuts across any decision by the government, be it tax, be it benefit, be it children issues, be it school, be it whatever. As long as the decision was made by government or an agent or arm of the government or a body of the government, councils and whatever, you have the right for judicial review. For the purposes of today's conversation, we're talking about a visa refusal or a visa cancellation, and therefore the body will be the Home Office. So Home Office, through its worker, a case worker, has made a decision to refuse your visa or to cancel your leave without right of appeal. In this case, you have right for judicial review. The reasons may be that, one, the decision did not follow the rules, and so it is not consistent with the law, and so it's unlawful. Or the rules were followed, but they were followed wrongly, and therefore the decision arrived at is unreasonable. Unreasonable. And if it is unreasonable or harsh, you can rely on that to seek review. Or it is perverse. Perverse in a sense that the facts and the conclusion do not match. And so it appears that the decision maker followed his or her own feelings to make that decision. You can also seek review on that at court. And so you appeal, you not the we won't use the word appeal. You apply to the court for the court to review that decision. And because it is the judge or the judicial process that will be used to review the process, we call it judicial review. The law to use
Now,
in
let me quickly, forgive me for interrupting, but let me quickly come in here and ask. You said you apply, and oftentimes you talk about appeal. Would there be any distinct difference between the two of them? Applying for a judicial review and appealing against the decision.
appealing against a decision is an inherent right that you will be given. So the caseworker will tell you that if you are not happy, you can complain by appeal.
Okay.
But
Okay.
when you are not told that you can complain or you can do anything, it means you don't have any right to speak. However, there is original remedy, and that original remedy is only sought from court by way
Okay.
of seeking the permission from the court for a review. And by seeking permission from the court for a review, you make an application, and that is called judicial review application. This is different from where you are told that you can appeal, and so you make an appeal application.
Okay.
That's the difference.
So generally, the law says that when a government representation, a government representative, a government institution makes a decision that you do not agree to, you can seek redress in court, and that's what we are looking at now. And in this case, we're looking at what the Home Office has said about your application, which you don't agree to, and you're taking it to court. Could that be a good summary of that?
So it's not a case that you are taking them to court. You are seeking a review from the court.
From the court, okay.
Because if you are taking them to court, it's like you have a challenge to mount and you are mounting it. But this one, they say you don't have any challenge to mount, so you can't take them to court. But then you tell the court that, court, can you please use your judicial lens to look into it?
Okay.
And that's the review they will make of it. So the difference between the two, again, is that appeal, you go to the lower court, what we call the first tier tribunal, to make that first tier tribunal to bring your case for appeal. But where there's no appeal right and it's just judicial review, you go to the upper tribunal. I call it the parent court. The children court is the first tier, the lower. The upper is, and from upper tribunal, you can go to Court of Appeal and Supreme Court if you still want to follow the judicial review process. So that is that. The court is required to use a rule book to review that process or that decision. The rule book is called Upper Tribunal Procedural Rules, 2008. And the procedural rules tell the time, tell the evidence, and tells what should happen by the person who is not happy.
Okay.
Now, the person who is not happy is the person whose visa has been refused. And so the person from the date of that decision has 90 days to tell the court to review it for him or her. And this follows civil procedure rules as well. As part of civil procedure rules, you have to tell the person who made a wrongful decision that you are seeking a review through the court. This is called pre-action protocol or a letter before claim. So the pre-action protocol letter will be sent to the person who made a decision, in this case, the Home Office. And that will include your reasons for seeking a review. And these reasons are called grounds. So you have your grounds for seeking a judicial review. You send it to them. Then, of course, as one putting the pre-action protocol, you include those reasons that you will be giving the court. The decision maker, the Home Office, will review the reasons why you are not happy. And the fact that you are not happy doesn't mean that something is wrong. And therefore, not being happy should be objective unhappiness. It should come from your head, not your belly. And the reason is that some people will just say that, I don't agree. But not agreeing with something doesn't mean it is wrong. That is emotional. But if it's coming from your head, It means that you have analyzed it and realized that objectively it is unreasonable, it is perverse, it is unlawful,
Okay.
inconsistent with laid down procedures, standards, and rules. And so it has to be reviewed for the right thing to be done. That is objective unhappiness. So let's set the two in context. Otherwise, somebody will leave here thinking that, oh, the lawyer said that if I'm not happy, I should complain. The fact that you are not happy doesn't mean the person is wrong. So let's get it right. Then,
Okay.
so your grounds or your reasons will spell out why you disagree. And the caseworker or the decision maker, through its own processes, will review your complaint, i.e. the pre-action protocol. Once they've reviewed, it will come back to you to say that we have reviewed it and we still think we are right. So you can go to wherever you want to go to. Your next step is to send a claim or application to the Court of Appeal to seek a judicial review. And you have to do, as we said, that within 90 days. So if you do it on the 91st day, you are late.
Okay.
There is a maxim in equity. Maxim in equity. Equity means fairness. And therefore, one of the rules in equity or in fairness is that if you want fairness, then you must be seen to be doing fair or being fair. And also, delay defeats equity. Delay defeats equity. And that he who wants equity must act in time. And that is the key maxim. If you want fairness, you must act on time. You are told that 90 days, and you bring it on the 95th day. Are you being fair to the process? True or false?
You're not being fair because you have delayed.
You've
You want to
delayed.
do it your own time.
You want
Meanwhile,
to do it
time
on
is not
your
waiting
own
for you.
time. Go, I like that. And delay also defeats what? Equity. Delay
Equity.
defeats
Yeah.
fairness. And so where there is objective delay, somebody will ask, what if the delay was something that is without control or couldn't have been avoided? Then you have to tell the court that I am mounting my request for review. However, I'm doing it out of time, and this is my reason. We call it extension for permission to bring extension of time for permission to bring a judicial review. So your application should include extension of time if you are bringing it after 90 days. And the question will be, how long should the delay be? The delay should be reasonable. 90 days after 90 days is no, no, no. 10 days after 90 days, maybe depend on what happened. 5 days after 90 days, okay, we can consider. And again, the court will look at all the circumstances. And one of the things the court will look at within the law, there's a case called Ono. Court says that, and also Denton. Court says that if you are bringing a request to extend time because you are late, one, you have to prove that the delay is not serious. And what we mean by delay is not serious is that we have to test the seriousness of the delay in terms of days. 1 day and 10 days, which is more serious.
Well, 10 days because it's a bit longer than a day.
Very good. And therefore, the longer the delay, the more serious it may be. And then you may not be able to get the extension. So delay should be limited delay and reasonable. And the next one is that whether delay could have been avoided and whether in all circumstances it is fair for the pleading or permission about the lateness to be still considered. If you're able to tick all the 3 boxes, then your request for extension of time to bring the application for judicial review after 90 days may, and the word is may be accepted by the court. based on the reasons for the delay and the principles for seeking extension of time. Right. So we know what it is in terms of judicial review. We are now
Okay.
looking at the process. And again,
Well, let me give you just a little breather, and we remind people of our social media platforms, and then come back before or when we come back, we will pick up Patrick's question, and he's asking whether anybody can apply for judicial review, even when the caseworker had correctly applied the rules. We'll be right back. We're still live on BWTV and streaming on social media platforms, Facebook and YouTube at BWF Solicitors and at BWTV. We're looking at judicial review applications against UK visa refusal or cancellation. We have looked at the law. We will be looking at the process you go through and what kind of evidence you take to the courts for them to consider your plea in front of them. But Patrick is asking Lawyer Charles Asma, and viewers, if you just joined us, our resource person is Lawyer Charles Asma from BWF Solicitors, proud sponsors and benefactors. Can you apply for judicial review even when the caseworker had correctly applied the rules? There's a question that was set off second point of discussion, Lawyer.
I thought we have answered this from the beginning.
Yes, I just probably point of emphasis and to satisfy,
yes. So
probably
we said
maybe
that
Patrick is just.
to bring a judicial review, you must show that, one, the decision is unreasonable.
Mm-hmm.
Two, decision is unlawful.
Right.
Three, the decision is perverse, any of them. So if our brother is saying that judicial review, the caseworker correctly applied the rules, then it will be a case of whether it is harsh in terms of the application or not. Harsh in terms of the application or not. But in all cases, it has to go against the rules. So if the rules were correctly applied, then you will struggle to achieve your aim of seeking a judicial review.
Okay. All right. So Patrick, that's the answer for you. Now, lawyer, you've taken us through what the steps to take, what the law is saying, what the law requires, and all that. Now, when we have satisfied every one of them, what do we do next?
Right. So we know that we are ready for judicial review. So the first is to go online and fill a form. The form is called UTIAC. 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 What does it stand for? UT means Upper Tribunal. I means immigration. A means asylum. And C means chamber. UTIAC. Upper Tribunal Immigration Asylum Chamber form. So there are different forms, and the initial application form is UTIAC 1. UTIAC 1. So you use the form 1, which is to bring application for judicial review. You fill the form, you sign the form, and you pay a fee of £174 to the court, and you make the application to the court online. It's an online platform. We call it e-filing platform for upper tribunal. If you are doing it through your lawyer would have the platform to make the application on your behalf. If you are doing it yourself, then you go online and do and you go online to sign up, and you'll be able to put your application through online. Now, because you are bringing a challenge, you have to have the evidence. So I think we'll be talking about the evidence. So the process is that you fill the form, you take one, you pay the fee, and you upload your documents and your evidence online.
Okay.
The court will then pick it up, review, and confirm. Confirmation by the court is called sealing. So the court will seal it. S-E-A-L, seal. Once the court seals it, the court will emboss it with its stamp.
Okay.
And once the court has sealed it, you have a reference number.
Okay.
You then have under Rule 9, to send, under Rule 28, the Upper Tribunal Procedure Rule 28, you have 9 days to send the sealing or the confirmation from the court to the opponent, that is the decision maker, i.e. the Home Office. So you have to then inform them that, we call it notice. You notify them by way of serving them that you have filed this claim against them. Once they receive it, they also have within the rules to acknowledge, to bring you back that, yes, we have received it and we acknowledge it, and And later they have to file their defense. And once you have sent them the notice of service and they have acknowledged it, you don't wait for them to acknowledge, actually. The moment you send them the notice under Rule 28, you go, that is A. Then the other part is that you have to go to court and tell the court that I have informed the Home Office about this claim. If you don't do that, then you have missed the point. So all must happen within the space of time. So 90 days to file your application for judicial review, you pay the court fee, you do all online, and you file your papers or evidence as well. Then you wait for court to seal it. Once the court seals it, you have the seal, you take it to the Home Office by filling a paper. Then you tell them that I have done this, and this is the seal from the court. Then you complete another form called UTAC 2. That's the Form 2. The Form 2 is the notice that you have served the other party. Then you send it to the court and provide proof that you have served the other party. And how do you show the proof? We are in modern age. What proof will you have that you have sent it to the Home Office?
So we're doing this online, aren't we?
You do it online, but when you are telling them, you have to send whatever it is to them. What's the quickest way to send something to the Home Office from the court?
So send it by email.
You send by email. So what's the proof that you sent the email?
So then you can print the sent email from your sent box.
And how do we know? How do we know that you sent it? Indeed.
So from your sent box, it will show you the time and date that it was sent on there.
Exactly. And the court will check against the rules whether it was done within 9 days.
Yeah.
Then you tell the court immediately. So you fill the form, you take 2, add the evidence that you sent the notice that you served the other side, print as you said, scan the 2, attach to your email. But in this case, you are not emailing the court. You go back onto the online platform to file it.
To file it.
So you go online and make an application to file the evidence that you have served the other party within time, and the court will pick it up, and that concludes the process.
Okay.
The next stage will be for the other side to bring their response, what we call defense, whether to accept it or to defend it. They will also do their bit and give you a copy and send to the court as well. And we wait for the court to manage the process.
Process. Okay.
The long
So
and short will be that
when the court receives material from both sides, the person who's brought the appeal or they brought the case for it to be reviewed, the Home Office defending, when they have received evidences from both of them, is the court going to call both to a hearing, or they will make a decision based on the evidence in front of them?
so the court will make make a decision based on, remember, it's an application to make a judicial review claim. So the court will receive the application and seal it. Then the court will make a decision on the application. The court will come back to say it is granted or it is not granted. Or even if the court says it is refused, you can still then say that it is refused because you only decided on the papers. What if I come in person to explain myself to you, judge? And the judge will say, okay, you have another opportunity to apply for oral hearing. So you can still seek oral hearing even if the paper application is turned down. But what we are saying is that once your evidence is provided to the other side, the Home Office, after reviewing, they may come back to say, you know what, we don't think it is necessary for us to fight this. And so we want to end the matter, or we are going to reconsider the decision. And reconsidering the decision, they will ask you, can you withdraw the case from court so that we can reconsider the decision that you are not happy about? If you say yes, you have to take your case from court, and Home Office will have to agree to sign a form, what we call consent form, with you. So the court will make an order that both parties have agreed for the case not to continue. The applicant is withdrawing the application, and the respondent has agreed to reconsider the decision. In addition, the respondent will pay the applicant their cost up to the point the matter is withdrawn. And once the consent is signed by both parties, court will stamp it to seal it. And once it is sealed, it becomes an order. And we call it order by consent. It's also a binding document. And so after 3 months, the respondent will have to review the refusal or the cancellation decision. When they reconsider, they can reconsider to cancel again or refuse again, or they can reconsider to change their mind. So when they say we are happy to reconsider, doesn't mean they are going to give you what you want. Remember, they can reconsider to turn it down again. The good news is that when they reconsider to turn it down again, your 90 days will start from the time they gave you the reconsidered decision. If you want to pursue again, yes. So you start the cycle.
So eventually you've provided your evidences, and the case would either end or pause when a decision is made either by the court to say the defendant would have to reconsider their decision or reverse it, or they themselves will come in to say, take it out of court, we are going to reconsider, and your 90 days will start from when they give you that one. That may end up the process or put a pause to it, isn't it?
Yes, that will pause the process. So the process will be stayed. That's the key legal word. Will be stayed at this point or paused for the consideration to go through. And once it is reconsidered positively and favorably, end of matter. If it is reconsidered adversely, then you can fight again. So you keep fighting until there's no more need to fight.
Okay, all right. And if you have an adverse reconsideration, do you go through the same process as you started, or you just continue from there because you have evidence in front of the judge already?
Yes. So you go through the cycle again. And as I said,
Okay.
it becomes a cycle. So so you keep fighting, fighting, fighting until there's no more need to fight. Either you will give up or they will give up. So
Wow.
survival of the fittest.
Well, obviously, if you have evidence that everything is gone against you, you would want to fight till you obtain justice and the right thing is done for you. If you just joined us, we're live on BWTV, and the program is The Community and the Law, and we are proudly sponsored and pushed by BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors, located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them on 0208 493 7340, 0208 493 7340. If you're going by public transport, use the Underground Victoria line to Seven Sisters. Use exit number 2, that will take you to the building, and you go to the fourth floor. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. And by evidence that we have been giving you, you realize that they do a good job at whatever it is that you sent to them. One bit of evidence is a friend who gave us the review. He gave a very nice review today, and he is saying that if you are facing any legal challenge, his strong encouragement is that you run to BWF Solicitors because you'll be in safe and capable hands. So I give you the number again, 0208 493 7340. And if you want to empower yourself through legal education, we have one on Thursday between 9 and 10 a.m. and another on Friday between 9 and 11, and then again on Saturday in the afternoon on the Community and the Law between 4 and 6 p.m. This afternoon, we've looked at judicial review application against UK visa cancellation and refusal. We've looked at what the law says, we've considered the process and the evidence that you need to give. I know you would have some questions to put to Lawyer Asma. It could be about the same topic, or it could be about any other thing that's bothering your mind. You can text that to us via WhatsApp or text message 07399208468, or you can put them in the comment section down below, either on Facebook and YouTube at BWF Solicitors and at BWTV. Loyaswa is here and he will help you answer all those questions. And remember, I've got the quiz that I gave you. 2 pieces of advice I've put before you. You need to pick up the correct one to help Julie Walker, who was granted 5-year leave to remain in the UK as a parent of a British child. Now, last month, this person we're talking about, Julie, was made redundant and has since exhausted her savings. She's now struggling to pay rent, buy food for herself and her son. Under her existing visa conditions, she cannot claim universal credit or housing benefit to prevent homelessness. She's worried that accessing public funds would affect her indefinite leave to remain application when she is due. Can we say to her accessing public fund will affect her indefinitely, so she should not dare? Or can we say accessing public funds would not affect her indefinitely, so she can dare? A short break. Take our social media handles, note them, and when we come back, Lawyer Asma will help us with your questions, concerns, and queries. Yes, yes, yes. And if you have stayed with us long, you very important to us, and we appreciate you. What we want you to do is to like the page and also share as well. If you're new here, subscribe to the channel so that when we put out any content, you'll be notified. And I tell you, you don't have to miss all the bits that we do online by way of legal education. You don't have to miss them for all the good that will say. Make good use of your time on social media and you will be well empowered, especially when we come to give you these legal education sessions. This afternoon, as I said, Lawyer Asma from BWF Solicitors has helped us to look at judicial review application against UK visa refusal and cancellations. He's taking us through the law, the process, and the evidence. Now it's time for you to interact with him and you put in your questions. I think that Citizen Kwejo has one that we can start with. Lawyer Kwejo is asking if an applicant submits a detailed subject access request, is it possible for them to obtain information such as names, date of birth, and even copies of documents they uploaded in a previous application or previous applications?
They have to apply for subject access requests
Mhm.
to get their data, and they have to ask for detailed report so that
Okay.
potentially everything that they have ever given to the Home Office can be given back to them.
Okay. All right. Citizen Kojo, yes, that's the answer. Thank you very much for bringing it up. Keep them coming through. The text number, as I mentioned, 07399208468. You can even give us a call on 0208 493 7345. 0208 493 7345. Danny Woods comes in. If you are refused of marriage not being genuine and you do divorce, can you add a divorce certificate when you're applying for a student visa? Lawyer.
If you receive marriage not being genuine and you
So
do
I'm
divorce,
thinking,
can
that's why
you
I'm saying,
add the
doing an
divorce certificate
application.
when you apply? Well, I think the bottom line is that you have divorced because you were previously married. So when you are
Yeah.
applying for a visa and the visa is based on a spouse, you have to provide a divorce certificate. If it's just a student visa, you don't need to add your marriage certificate or divorce certificate and for student visas unless you are applying as a dependent of a student. So Danny, if you're applying as a student, then you don't need to add your divorce and marriage certificates because that is not a requirement for student visa.
All right. But maybe for purposes of emphasis, I'm a student. I have a partner. Previously, I got married, and uh, you are saying it's not necessary because you haven't been asked that, isn't it?
When you are making an application, you give them what you need for that application.
Okay.
So student application is your application. So your CAS, your passport, your other documents required. That's what you give them. They don't ask you to provide information unless, of course, somebody is sponsoring you, your wife is sponsoring you, or your husband is sponsoring you. Then you want to prove the relationship between yourself and the sponsor. Then you can add the relationship evidence. But in this case, divorce is not a relationship evidence.
Okay. All right. I get that. Thank you very much, lawyer. So keep them coming through. We're picking your concerns and questions. Kwajo Tufo is watching us from Hammersmith. Thank you, Kwajo. Thanks for being there all the time for us. We appreciate you. Patrick says thank you very much for the response you gave earlier on judicial review question that he brought in earlier on. Thank you very much. Papa J, my friend wants to bring her wife and meets the salary threshold, but lives in a shared apartment. Can he go ahead to start this particular application?
My friend wants to bring her wife and meet the salary threshold, but lives in a shared apartment. Well, I mean, if you live in a shared apartment, it doesn't matter. All you need is one bed, and you have to show why you have permission to live at that property. So proof of tenancy or a letter from whoever is um, hosting you. So it doesn't matter. You don't have to buy your own property, or you don't have to rent 3 rooms or two bedroom flat alone if you don't need it. All you need is one room in a shared accommodation, and your wife or husband will join you. Unless there are children involved, then you need to show other rooms.
Okay. All right. So, my friend, yeah, I think you meet the requirement if it is that it's just you and your wife in the situation, as lawyer has explained. 0208 493 7345, or in the comment section down below on Facebook at BWF Solicitors, and YouTube at BWF Solicitor. What is the way forward after your customary marriage application is refused, even though you meet all the eligibility criteria?
So what is the way forward after your customer application is refused, even though, well, the way forward, if you are not happy, go to court. Simple. It's a family life application, and therefore you have automatic right of appeal. That is all you can do. Otherwise, you have to apply again.
Okay. All right. Wester, thank you very much for bringing that through. We'll move on to the next one, and it's from Papa J. I think he brought in a question earlier. Let's see this one as well. After application on private life is made and you change your proof of address, is it going to affect your application? Please, how do you prove a genuine and subsistent relationship?
So genuine, oh, I think there's something the person said. Application is made and you change your proof of address, but it's private life.
Hmm.
You change your address, yeah? And please, how do you prove genuine and subsistent relationship has nothing to do with private life. Private life is your life in the UK. It's not about your relationship to anybody or with anyone. So you don't need the genuine and subsistent relationship is under paragraph RWP 6.1 to 6.2 of appendix relationship with partner. That means the person is a dependent and applying on the basis of their spouse. And with
Okay.
that, you have to show there is genuine and subsistent relationship. In that case, you will not be talking about private life. You'll be talking about family life, unless the question is two. So let me answer in twofold. The first
Hmm.
part is that private life. If I change my address during the time my application is with the Home Office, will that affect my application? No. Home Office will not write to you. Everything is email and it's online. So it doesn't matter if you change your address. If you change your address, uh, they are not going to post anything to you anyway. So, but if you change your address, you can also tell them that you've changed your address and they will amend their record. The second part is family life as a spouse. How do I prove genuine and subsistent? Genuine means you are genuinely married or you've been
Hmm.
together for 2 years, even though you are not married. In this case, what you have to do is show that that relationship is ongoing, which is the subsistent relationship. Is subsisting, not subsistent. Subsisting. So that subsisting relationship means that it is ongoing. How do you prove that it is still ongoing? That is why we ask for proof that you are living together. Proof that you are living as husband and wife, talking, photos, um, sharing bills together, all those things. And that's why we need such evidence. Otherwise, why will you provide photo if you are making an application? But to prove that you have a subsistent relationship with that person. So these are your family life photos. Again, conversations, communication. If you have a subsistent relationship with a partner or someone, you keep the engagement conversation going. And that's why we ask for proof of communication. If you have something like that with somebody, you keep the life activities going, the bills, who pays the bills, if you are paying together, what shows. Again, living together. Are you living together indeed? If that's the case, what's the proof that you are living together? And all that. So my brother or sister who asked the question, that is what we mean by a subsisting relationship. And these are pieces of evidence that you can use to prove.
Keep it coming through. We still have time with Lawyer Charles Asma from BWF Solicitors. The program is the community and the law. Pa Bright says, asking if you applied for settled status, how long does it take to get a response?
Okay, if I apply for how long? It can take 6 months, it can take 1 year, it can take 9 months. So if you didn't apply under priority service, which takes about a week, standard service can take a little longer, minimum 6 months, can be earlier than 6 months, but average 6 months or 9 to 1 year.
Okay, thank you, Pa Bright. Thanks for your questioning. Thank you, Lawyer Asma, for your response. With a new law about no recourse to public funds, can you elaborate more about it? Is it for family members only and not spouses included?
Right. Now, no recourse to public fund is not compulsory. If I say not compulsory, you don't have to ask for government support if you can support yourself. So that's the first thing. So if you don't have money, and for not having money, you cannot live as human beings will live for your essential living needs, your clothing, your shelter, your food, then you tell the government to allow you to be given support to meet those essential living needs. It's mainly for families with children. And the conversation here is for applicants who are on no recourse to public fund, applicants, not the spouses. If your spouse is on or is receiving benefit, you are not the one receiving benefit. So it's not you. It's you, the applicant, who has been given no recourse to public fund, and you decide to go for recourse to public fund. Ideally, your visa time should change. But what they are saying is that it is no longer going to change. But this doesn't apply to anybody, as I said. So somebody may be a parent. The person applied based on their child or stepchild, and they ask for benefit, and they are getting the benefit because they need to feed themselves. They don't have to. The government is now saying that they will not have to be converted from 5 years to 10 years, simply because they have now had access to public fund. But if you are a spouse, and you, the spouse, there's no child involved here. You, the spouse, are working and earning enough. You don't need public fund. So this conversation is not for you. But if your wife was on benefit, or your wife wants to go on benefit, that will also not affect you, but you are not the one. So it's simple. So simple. And the simplicity is that if you are on benefit as a parent and you are scared that if you take benefit or you enjoy the benefit, it will affect your visa, you don't have to worry. But if you are a spouse, you cannot even go on benefit if you are a spouse. So it doesn't apply to spouses. This is mainly for parents on the 5-year route based on their children. And again, even though this is good news, I say that it is not so good news. And my reason is this. We know that from autumn 2026, the government is going to introduce a law that those who are on benefit will have to stay longer before they can get indefinite. So the question is, if I'm on 5-year route based on my child, and you said that parents on their children who are British citizens are not affected by the long stay for indefinite, but you also say that those on benefit will be affected, then what they are saying is that if you are on 5-year route, you can go and get benefit, no problem. However, there's another law which says that if you take benefit, it will affect you. So you have to decide. Because the moment you go for benefit, if they don't get you at point A, they will get you at point B.
They're taking it away with the right now. And what I was saying is that it's like they give it to you with the left and take it away with the right.
Basically, that is why it's a forbidden port. You don't go near if you have issues.
Well, somebody said he liked the forbidden port expression that you gave. Well, folks, we still have time for a few more of your questions and concerns. Keep coming through. Nanania says, Janet. Oh, okay. Nanania, you. Okay. It looks like my quiz, but let me go through it. It says that Janet came to the UK in 2023 on a health and care worker visa with her husband as her dependent. In 2025, she changed jobs under occupation code 6135, but did not include her husband in the new visa application. She later divorced him and informed the Home Office. She wants to know, 1, can she remarry and bring her new husband to the UK? And 2, can she bring her children to the UK as well? Lawyer.
Well, as long as she qualifies, she can bring her dependents. If the dependents are children, she will have to show that there's no issue about sole responsibility.
Okay.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Brakweku, your mic. Brakweku, you are muted. Brakweku, you are muted. Right, so...
Can you hear me now?
Yes, it's much better. Yes, go for it.
Oh, okay, all right. I think we were having some challenges with the stream, but if Lawyer can hear me now, let's pick up the nugget again and look at the question. Then we see what answers people have given us. So let's see the bit about the no recourse to public funds thing that the Home Office has made, and it says applicants on the 5-year family or private life route can now be granted leave with access to public funds. And the key points, as I mentioned earlier on, that it applies where there is destitution or risk of destitution, when there is strong child welfare issues according to Section 55, or exceptional circumstances in the life of a child, and no automatic switch to the 10-year route. So I gave you one scenario about our friend Julie, who was granted 5 years leave to remain in the UK as a parent of a British child. Last month, she was made redundant and has since exhausted her savings. She's now struggling to pay rent and buy food for herself and the son. Under her existing visa conditions, she cannot claim universal credit or housing benefit to prevent homelessness. So what we're saying is she's worried and wants to know whether she can apply for the public funds, and that it will not affect indefinite when it is due. Is it one or two? If your answers coming through, then when we have picked a couple of them, we'll go to Lawyer Asma to find out what the correct answer would be. So let's see what answers you have brought, as it were. Alexander Raymond Ishan says that is number two. Accessing public funds will not affect her indefinite. Thanks, Alex. The next one is from Nanaba Ziuza Champon, also says number two. Thanks, Nanaba. The next one is from Stephen Angama. Stephen says accessing public funds will affect her indefinite, so she should not dare. The next one is Ajua Sewa. Ajua Sewa is number two. Accessing public funds will not affect indefinite. Jenny Fenchua says it's number one. Thanks, Jenny. The next one is from Ruth O'Donnell. Ruth O'Donnell says that it is number two. Accessing public funds will not affect indefinite. The next one is from Bennis Doe. Bennis says it's number one. Accessing public funds will affect indefinite. Nanefia Blinks also thinks that it is number one. Accessing public funds will affect her. Kobe Stone also thinks it's number one. It would affect her indefinite. Richmond Osubwedi, number two. Accessing public funds will not affect her. Gloria Asante agrees with that. Tilly Duma comes up with number two. Gloria Asante, yes, number two. Thank you very much. And Tilly also says number two. I think mentioned Citizen Kwejo also says is number two. Now let's go over to Lawyer Charles Asma. Betty Onyewa, yes, I can squeeze yours through. It's number two. Lawyer, is it one or two?
So we know what the law says. So we go to the law. And what is the law? According to the nugget, applicants on a 5-year family or private life route can now be granted leave with access to public funds. And it goes on to say that this is good for the children, this is good to get them out of destitution, and this should not lead to automatic switch to 10-year route. Therefore, applicants can stay on a 5-year path to settlement, even if they have no recourse removed. And so no recourse is now flexible not absolute. It's a discretion. So technically, it will not affect the individual because it's going to be a case by case. Well, now let's look at Julie, whether her case is such that it should or it shouldn't. We are told
Okay.
that she is experiencing destitution. We are told that she wants to have access to public funds. What she's worried about it, whether she should go for the forbidden pot or she shouldn't because it will affect her independence. And we are told that no, it will not affect her independence because the forbidden pot now will have discretion to decide whether there should be adverse or no adverse effect. And therefore, this will not affect her indefinite leave to remain. The answer is 2.
But lawyer, in that discussion, you mentioned something. I suspect some people changed their minds from 2 to 1 because you were saying that in autumn 2026 there may be that introduction where it will affect them. But can we say that for now that is what the situation is, and so 2 is still correct?
Well, what we are saying is that there is danger 1 and danger 2 for those going to the forbidden pot.
Right.
Danger 1 has now been removed. Danger 1 was that if you went to the forbidden pot, you will be converted to the long route, which is 10-year route, and that will take you another 5 years to get to indefinite. And so the good news is that that journey has been maintained. Whether you go for it or you don't go for it, you still remain on the fast train to heaven, literally. Now,
Okay.
there's danger 2, and danger 2 is it's not a condition to danger 1. It's a standalone danger. Government is saying that with or without danger 1, all those who are on benefit will be affected because from autumn 2026, if you are on benefit for 1 year, you have to wait for 5 years. If you're on benefit for more than 1 year, you have to even wait longer to get to indefinite. So somebody who was on 5-year route got benefit because the danger has been removed at the danger 1 level. Now they have introduced danger 2. As we said, you thought you are free only to be told that because of this, there is another danger. So if you are free from danger 1, there's still danger 2 waiting for you. So is it really worth going for it if you can survive without this pot? A word to the wise is not in the law.
Well, thank you very much, Lawyer Asma, for that. A word to the wise is not in the law. If you would need any support with your legal matters, the explanation, the bits that you need to know, and all the steps you need to take, I recommend that you speak to BWF solicitors, our trusted partners, when it comes to the law, especially with immigration matters here in the UK. Visit them on the 4th floor of the other house, 214 to 218 Tottenham High Road, Seven Sisters in North London. Call them on 0208 493 7340. Today we've spoken about what we can do when we have a refusal of our application. A judicial review is the bit we talked about. We looked at the law, the process, and the evidence. Lawyer Asma led it, and I think by tradition and customarily, I will ask him to give us a brief summary before we draw the curtains down. Lawyer, back to you.
Thank you very much, viewers and listeners. Today we looked at something that most people are already aware of, judicial review. And we said that judicial review cuts across. It's not just for immigration, it's for everything and anything. And anytime the government, through its representatives or agents or workers, makes a decision that is inconsistent with laid down standards, laid down procedures, laid down rules, that decision may be unlawful, that decision may be unreasonable, that decision may be harsh, and therefore may be a reason for a judicial review. Judicial review will have to be brought within 90 days, and it has to be done by the online court platform called e-filing. If you're an individual, you have to create an account to do that. If you are represented by a solicitor, the solicitor will have an online account to be able to do that on your behalf. The point we have made is clear, and it is that if you are late to bring the judicial review after 90 days, you have to seek extension of time to bring the review. The review process falls within Upper Tribunal Procedural Rules 2008 if it is for immigration. If it is for non-immigration, again, the same procedural rules, because Upper Tribunal is the one that receives your application for judicial review. Once you file your application, the court will seal it and give it back to you. And you have 9 days within the court procedural rule 28 to bring the notice to the other side, that's the respondent, that I have filed and the court has received it. If you don't do that and you are late after 9 days, then even though it's been accepted and sealed, it cannot go forward because the other side has not been notified. Once the other side is notified and the other side has confirmed that, of course, you don't have to wait for the other side to confirm. Once you've notified the other side, you have to tell the court that you have notified the other side. And that is also crucial. If you don't do that, then the process cannot continue. Once the process is followed through and the court accepts that this is it, the other side will have to file their defense, or the other side, during the process, the court is yet to make a decision, can say that we want to reconsider the decision. The reconsideration will then store the process. In this case, it has to be by consent, and the court will have to approve the consent by way of a consent order. The other party must follow or comply with the consent to reconsider the decision. Reconsideration doesn't mean that they will change their mind. They can come back and say that we have reconsidered and maintained the original decision. However, once it happens like that, you can start the judicial review process again from day one, from the date the reconsidered decision is given to you. And your 90 days will start all over again. You have to go through the same process as before. It can go on and on. Normally, the judicial review application is decided on the papers. Once it is decided and the court disagrees with you and agrees with the respondent or the government, you have opportunity to tell the court that I need oral hearing because it was on the papers. That's why maybe it was decided in your favor. You want oral hearing. You have to then make an application to court for the matter to be opened for hearing orally, and the process will continue again. So this, by and large, is the process for judicial review. In terms of evidence, it's everything that you need to prove that the decision is unlawful or is unreasonable or is perverse or is harsh. And gather the evidence, the reasons or the grounds, and file it with your application to court and serve the other side as well and wait for a decision from the court. These are time bound, and therefore you have to make sure that you operate within the rules by keeping to the time and meeting any direction requirement that the court provides for you to respond to. Thank you for your attention.
And thank you very much for your time. Thank you for the patience you have for us. And thank you for serving the community always with a smile. And thank you to BWF Solicitors for giving us this opportunity. Citizen Kwajo says that the key word for today is forbidden port. Don't put your hand in there if you think that you could be in trouble. But Lawyer Asma also said, a word to the wise is not in the law. It's been the community and the community and the law, so to speak, live on BWTV. We have worked together for the past 2 hours, and it's been a wonderful show. I want to say thank you very much once again to BWF solicitors for their time, for their effort, and of course the encouragement to empower the community with legal education. To Charles Asma, lawyer Charles Asma, thank you so very much again. We can't thank you enough for your time this afternoon. And to you out there, we wouldn't have had a good program without you. So those who liked the page, who have picked a link to share, and also commented and brought in your question. If we didn't have time to answer your question, don't worry. It will be brought up another time. No worries, because same time next week we're coming back. I worked with Sheila and Krapad Modotu, and my studio director producer is Professor Adair. My name once again, Ureko Fripon. I'll meet you same time next week. Until then, be good.